Thank you.
Ms. Sotomayor?
Your point is statutory history, so do I. And I take seriously the fact that the originals, both Senate and House bills here under Title III, included a waiver of the FSIA. And so it's not clear to me that when Congress took it out, why we would be putting that waiver back in.
So, Justice Sotomayor, if you really dig in on the legislative history, I think it becomes clear that Congress did not change its mind on whether to abrogate. It changed its mind on whose immunity to abrogate. So in February of '95,
So why didn't it say that directly? I know,
Well,
but that's assuming that it's clear that it took out the Cuban government and substituted subsidiaries and agencies, correct? That's what you're
correct.
relying on.
Correct.
But that still begs the question. The DOJ had made very clear that abrogating sovereign immunity of the government and its instrumentalities would be a violation of international law, correct?
That's correct.
All right? So it took out any suggestion that it was abrogating sovereign immunity, dropped it from both bills, dropped the federal government but kept foreign instrumentalities. But from that history, why would I assume that it was intending to abrogate immunity?
Justice Sotomayor, that is not the correct history. The history is February of '95, the original bill abrogates immunity under the FSIA for governments themselves. Then there's an outcry about various aspects of the bill. But August of '95, they take out that immunity provision and they add in this specific reference to claims against agencies and instrumentalities.
But that doesn't make any sense to take it out, to take out the waiver of FSIA, because FSIA goes both to the government and to the agents and instrumentalities, and the government's letter was complaining about all of this being in violation of international law.
So, Justice Sotomayor, two quick things. One is the FSIA provision, Section 1605, although it does cover both foreign states and agencies and instrumentalities, there's no specific existing provisions carving out just agencies and instrumentalities. So although I could write that language for you, Congress did not have a copy and paste job once it got rid of foreign states. And second, if you are looking at that legislative history, I do think you have to look at the fact that the State Department, 2 months after this amendment, continued to say, well, now it applies to agencies and instrumentalities, sure, but it is still going beyond the FSIA. That likely ground the bill to a halt in the fall until Cuba shot 2 planes out of the sky, and all of a sudden supermajorities of Congress passed, and the president signed this law within 17 days.